If I may please the court, my name is Crystal Morgan with Morgan Legal Services. I am co-counsel with Unite the People, Inc. and the Baez Law Firm for Mr. Daystar Peterson, who is the appellant and the defendant. We wish to begin by acknowledging the harm expressed in this case. For those that were affected, our arguments today are presented with the unwavering belief that our client, Mr. Peterson, is innocent, with the utmost respect. It's important as we would like to clarify that any display of empathy should not be considered an admission of guilt. That guilt is established in the bedrock of our criminal procedure that is from the prosecution. And in this case, that was riddled with numerous errors. That standard was not met. We believe the most compelling arguments are the testimony of Ms. Kelsey Harris when looking at the Confrontation Clause, prosecutorial comments in the opening and closing statements, and Brady violations that cumulatively occurred throughout the trial. To start with the Confrontation Clause, particularly with Ms. Harris, who was present in court and also present on the night in question with Mr. Peterson, Ms. Pete, and Mr. Smith on July 12th, 2020. Ms. Harris gave testimony on December 14th and 15th. These dates are important to note, but she only gave that testimony after asserting her Fifth Amendment rights. With the Confrontation Clause, what we must do is a very fact-specific analysis, and we must weigh Ms. Harris's right to not self-incriminate with Mr. Peterson's right under the Sixth Amendment to confront those witnesses. Because of this, we have to analyze this and take it step by step. So the first step is seeing if we have a testimonial statement. And this is according to Crawford v. Washington, 2004, 541 U.S. 36. These statements were further defined whether to be testimonial or non-testimonial by the High Court in Davis v. Indiana, which is found at 547 U.S. 813 in 2006. Statements are testimonial when the emergency no longer arises, when the statement is being given in response to a future prosecutorial event. So we know that Ms. Harris, when she gave her interview with the district attorney's office, was giving a testimonial statement. Therefore, the first prong is met. But the second prong is not so easy to establish. We need to determine if Ms. Harris was available or unavailable, which is a little tricky in this case, which is why we need to walk through each step. So Ms. Harris walked into court and said, I exercise my Fifth Amendment right. That made her unavailable. But when they granted her use immunity, she was thereby available again. Yet she still got on the stand and testified in a manner that was not consistent. She said, I don't remember. Or she said, I was dishonest in my interview with the district attorney's office. Therefore, because of the way she was testifying, they decided at first to take this interview, which at the time we did not have a transcript for. And they were playing portions of the recorded statement to refresh her memory that the jury heard. So at first that was going on in her direct. Then in her cross-examination, as she continued to testify in this varying manner that wasn't the way everyone expected her to testify, they entered the entire recording into evidence. But that recording was not entered into evidence while Ms. Harris was giving her testimony. It was entered into evidence on December 16th. And at that point, this is when the defense received that transcript, which we argue not receiving that transcript was a violation of Brady, and it also was a violation of Penal Code 1054.7, Your Honors. So we have this now statement in evidence, which is a transcript of a testimonial statement given to the prosecutors. In order to get this into evidence, they have first argued that they were going to use it to impeach Ms. Harris. This is because in their opening statements, the prosecutor said that Ms. Harris was going to testify that Mr. Peterson had violently pulled her by her hair from the car. This is a fact that was not proven at trial. Ms. Harris did not testify to this. Therefore, we feel that also is one of the inappropriate opening arguments. But additionally to that, we strongly objected to the late discovery of this transcript. And it wasn't just the late transcript. There were numerous other instances that the trial attorney did object to. But nonetheless, ultimately, the court did admit this statement under both Evidence Code 1235 and Substantive Evidence, Evidence Code 770. So now it's in, and we have a very unique situation here where we have a testimonial statement. We have a witness that doesn't want to give us answers and is saying I was mistruthful in my interview only in September of 2022, and this trial was in December of 2022. So it's clear that she did not want to cooperate. She said as much on the stand, I don't want to be here today. As a result, these matters, we feel that we need to look at the reliability and the prejudice to Mr. Peterson. And as Ms. Harris stated, I didn't tell the truth. So we can't rely on these statements from her own words. And this did greatly prejudice Mr. Peterson because in that interview, Ms. Harris said, my friend and I were attacked and it was this man's fault. And then at trial, she did not verify those statements, but the jury still heard those statements nonetheless. And we know that the jury relied on these statements because during deliberations, they did ask for a copy of that transcript to further analyze it. Therefore, we feel that the totality of the circumstance really does show that Mr. Peterson didn't have a chance to confront that witness in the Sixth Amendment context. Additional errors occurred throughout opening and closing statements. Start with the opening statements. We heard the prosecutor promise that he was going to put Mr. Justin Edison on the stand and that Mr. Edison would say that the following day when Mr. Peterson met with him to give Ms. Pete and Ms. Harris's belongings to him, that Mr. Peterson confessed that he did this crime. So the jury in opening statements at their first introduction to Mr. Peterson heard he's guilty and he said so, and I'm going to put a witness on the stand to prove it. But Mr. Edison never testified in the trial. Mr. Edison was not being cooperative with the prosecutors. In fact, in November 28th, 2022, the court had to put a body attachment onto Mr. Edison. And on December 5th of 2022, Mr. Medesian, our trial attorney, actually filed a motion in limine specifically for this. And he stated that he was very concerned that Mr. Edison not coming to court would severely prejudice Mr. Peterson. And he urged the court to not allow such statements in opening. This motion was not granted. And so the court heard that Mr. Edison was going to testify. When Mr. Edison didn't show up due to media coverage and comments made in the trial, it was implied that Mr. Peterson was responsible for Mr. Edison not being in court with no proof of such contentions, which further prejudiced the jury. The body attachment continued at that point, and he still did not cooperate with the prosecution. We know in California, due to Hawk v. Superior Court, which is found at 42 Cal App 3D 108 in 1974, this is the controlling case that supports the contention that opening statements are confined to a reasonable good belief of what the prosecutor feels he will be able to show in the trial. Reasonable good faith, arguably, very respectfully, is not having a body attachment on a witness. The witness may or may not be trying to avoid the process. We don't know. He's just not there. And so that's all we can rely on. And ultimately, what happened is exactly what Mr. Medesian was afraid of in his motion in limine. And what Hawk warns about is that we must have this reasonable good belief in these opening statements to promise something, especially when it comes to a confession, because the jury is going to believe the prosecutor. They're going to rely on those words and have the prosecutor guide them and direct them to show why Mr. Peterson was guilty. So because of the great weight that the jury naturally gives the prosecution, we feel that these statements were inapposite to a good faith belief. Generally, a court would give a limiting instruction and attempt to cure such a situation. But in Mr. Peterson's court, no such instruction was given. There was no curative instruction for these opening arguments.
So let me ask a question here. So are you arguing that any time a witness is subject to a body attachment, that should be, that any reference to that witness should be off limits in opening statement?
I think that the prosecutor should be extra careful in such a situation because they're going into this knowing that that witness is not cooperative. So I think that if they say that they hope to produce such a witness, that perhaps would be enough. But here, there was just no hesitation. And I think it's especially true in the case of the evidence that we're dealing with Mr. Peterson, that it was a confession.
And so what was the evidence or indication that the people did not have a reasonable good faith belief that they would be able to produce Mr. Edison at trial?
We actually have no proof of the district attorneys ever speaking to Mr. Edison. The defense was never provided of a copy of any interview that they conducted on this witness. We have no physical evidence. All we have is an email from the district attorney in this case that said, I didn't disclose this and I meant to disclose it, but we are going to call this witness who will say that Mr. Peterson confessed to him. So I honestly, despite my best investigations, we cannot find where this statement came from. We cannot ascertain the veracity of these statements. That's why I think it's inappropriate. I don't think it's always inappropriate, but in this case, with these particular facts, I do feel that it's inappropriate. And there was also problems in closing arguments, which contained inaccuracies, and it presented the evidence in a way that misconstrued the actual results. Here, I'm specifically talking about the DNA evidence. So we heard the prosecutor close the case by telling the jury, don't be fooled when we hear that Mr. Peterson is excluded. But that's not exactly what the evidence said, which they had in their possession. I feel that statement really misled the jury. It may have confused them. It played on their emotions. And we know that that's not appropriate in closing statements. And in order to really understand the weight of that statement in closing, we need to understand what the evidence was that the district attorney had available to them. So as shown in our brief, in our reply brief, as for the magazine, there were 4 DNA profiles discovered on the magazine, none of which that were Mr. Peterson. Therefore, he was excluded from the magazine. As far as the firearm goes, they also found 4 different samples, one of which was a 90% male contributor. But Mr. Peterson was excluded from being that 90% contributor. Therefore, telling the jury, don't be fooled when you hear he's excluded is just not quite as the evidence showed. And to illustrate this, I want to clarify some key terms in science. So inconclusive, we heard in trial testimony, means it's not positive, it's not negative, it's just a neutral result. But it's not quite as simple as that. Actually, according to the scale of a likelihood ratio, which was in the discovery and presented at trial, likelihood ratios are the percentages. And we did not hear any percentages in Mr. Peterson's case, even though this evidence was available to the prosecution. This evidence was only given to defense upon our expert witness's request. So we did receive this evidence late. So this evidence was not presented in trial. It was presented in the motion for a new trial. But what we can see is that likelihood ratios that are 0, 0.01 and below are considered to be excluded. Likelihood ratios from 10,000 to 999,099 are very strong, very strong support to the prosecution that this person did leave DNA on this item. And then above 1 million is very strong. We found in the DNA evidence that they labeled Mr. Peterson's LR to be inconclusive and uninformative. And uninformative, according to this scale, is this an LR of 1. Therefore, Mr. Peterson had an LR of 1 in a million that his DNA was on this firearm. And with that fact, it is actually marginally more likely that another member of the African-American population touched this gun over Mr. Peterson, which the jury did not hear. The jury heard the district attorney say, don't be fooled. But there's also no proof that Mr. Peterson did anything to fool anyone about this evidence. He presented his defense. It was their testing. We went off of what their testing said. So I just think that that is a very strong contention. People v. Berryman in 1999, 21 Cal 4th to 50 is a significant California Supreme case that addresses the standard for overturning a conviction due to prosecutorial misconduct. It's a principle, basically the key outcome of that case was that we must show that this misconduct materially affected the outcome of the trial. And it did, because if our jury had heard that Mr. Peterson, maybe 1 in a million, touched the gun, I believe that would have been enough to tip that scale and show reasonable doubt for them to find him not guilty. The jury just didn't hear that. They heard that Mr. Peterson hoped that they would be hoodwinked in the alleged closing arguments. So due to these statements and the misconstruing of the evidence, we feel that that was a very significant issue in the case. And finally, we feel that the Instagram post, as we discussed in our opening brief, this was a Brady violation. This post was given not only late, but it also was not redacted. It was riddled with hearsay. This post is significant as it also implies a confession, because what we have is actually various people posting, and this was in September of 2020, and they were posting that people were saying that, oh, well, if Mr. Peterson didn't do it, then Ms. Harris must have done it. And Mr. Peterson's social media manager commented on this post, no, they're not. And so that was used as an admission. But many celebrities don't run their own social media accounts. This is significant because, number one, had that discovery been given timely, we could have provided the statement that was provided in the motion for a new trial by Mr. Farias, stating that he is the one who runs Mr. Peterson's social media account. He made that post, and he didn't ask Mr. Peterson before he made that post. So that right there, we could have, if it was not late, presented a defense. But because we didn't have that, we were caught off guard. We were always in a position of reactive instead of actually being able to produce a good defense on this case. The Brady rule provides...
Let me just ask one question at one thing you've said.
Yes.
Were there requests for redaction of that exhibit or of the post?
I believe there were, yes. Mr. Medesian did do a very good job objecting throughout the trial. We also must remember that Mr. Medesian only took over this case 2 weeks to a month prior the start of the trial, because the first trial attorney did withdraw and was permitted by court. Yet, I understand the court allowed that, but as an attorney, that's a very big feat to step in the shoes of another attorney so close to the trial. So I feel that all of these arguments we're discussing today, we do need to take that into consideration overall with them and think, in the alternative, this could be an effective assistance of counsel. But the Brady rule provides that this exculpatory evidence must be provided to defense whether or not a request was made. The suppression of this evidence, it doesn't matter if it's willful or accidental, so long as it was suppressed, then that is the problem right there. And I do have a 3-part test, which is found in the United States Supreme Court in Strickler v. Green, which is 527 U.S. 263 in 1999. They reiterated the 3 components of a Brady violation. The evidence must be favorable to the defendant. Here, yes, the evidence was favorable. Had we gotten that Instagram post earlier, we could have brought that declaration in trial saying Mr. Peterson doesn't run his own social media accounts. Had we gotten the DNA evidence and not had to request that from the prosecution, we could have prepared for a better DNA argument, having the full picture. Had we had the testimony, the transcripts from Ms. Harris's interview, we could have countered that. We could have questioned her on cross about her interview. We also likely did not get fingerprint evidence on time. We did not get, and the fingerprint evidence actually showed that Mr. Peterson's fingerprints, were not found on that weapon. Currently, we are attempting at the Superior Court to have them run the serial number to identify the owner of the weapon, which was not done. And we are also attempting to retrieve either a recording or a transcript of one of the key witnesses' testimony. One of the key witnesses in the case, Mr. Sean Hawley, who gave testimony. We're attempting to get a copy of his 911 call.
Wait, you said Sean Hawley?
Sean Kelly.
Oh, okay. I'm sorry.
Yes.
I thought you were referring to counsel who's female. Okay.
Yeah, no, very close. Yes, Sean Hawley was the attorney. Sean Kelly was the witness.
Okay, got it.
Different spellings also. So obviously we can see that this is favorable. The second question under that 3-part analysis with Strickler was it suppressed willfully or accidentally? Yes. This evidence was suppressed. All of these different pieces to where Mr. Medesian said, I feel like every day I wake up and I have an email from either the night before or the morning of saying, oh, we missed giving you this. And very respectfully, I say that. And the final component of this three-pronged test is, would it have changed the outcome of the trial? Yes, absolutely. If our jury could have heard the full picture, the full accurate picture of just the evidence being laid out as it was, without these don't be fooled and, late discovery, I feel that it would have really tipped those scales to reasonable doubt to find that Mr. Peterson was innocent. And that's why today we humbly, humbly pray for exoneration of Mr. Daystar Peterson.
Thank you very much.
Thank you.